How's it going? Can you believe he's got us working the weekend after Thanksgiving? I think it's ridiculous. Nobody watches this stuff. Oh, look. There are a lot of people there. This is all about creditor protection. Well, they're going to be disappointed. Oh, look at that. Turn your camera off. Or maybe turn your camera on later. Oh, what's behind me? Oh, there. Oh, so anyway, I'm sorry to tell you that Brandon's not here today. He's had enough of this stuff. He's taking the week off. We'll start very soon, 1 minute, also known in this law firm as 1/10 of a billable hour. Okay. I hope you enjoyed our high-tech, well-written pre-show and that you're having a fantastic Thanksgiving, as evidenced by the fact that you've broken away from the family and you're watching this instead. But we all have a lot to be thankful for, and I'm very thankful for those of you who are attending this or tape recording it. And I'm thankful to Kelsey, who comes in every Saturday to get this set up. I did it last Saturday without her, and I forgot to hit record, so I'm going to have to rerun the Florida talk. I want to thank Dummy McPuppet. Oh, thank you, Alan. Move your mouth. Yeah, okay, whatever. I want to thank Brandon Ketron for always correcting me and making it clear when I've made a mistake during a presentation. I want to thank Debbie Gray, who always does the slides, who helps Kelsey with the slides at the last minute when I change my mind about what's going in them. And I want to thank you, the audience. You're the most tolerant audience in the whole of the nation. Speaking of friends and gratitude, at the end of this presentation, I'm going to play a little interview I did with one of my mentors, Professor Srikumar Rao, a retired business professor from Columbia University, in a program he's offering in February, which will be a good fit for some of the people on this webinar and for people you know. Okay, we are talking about part 2 of creditor protection. A few weeks ago, we covered part 1, which is on the YouTube video. For those of you who are new to this webinar series, you have my sincere apology for the mediocrity of the production. The puppet's as good as I can get. If you're a professional, you should probably go somewhere else because we don't qualify for continuing education credits. We're afraid to ask. You will get within 3 to 5 hours an email with a copy of the recording of this and the PowerPoint slides. So you may want to block these emails or forward them to anyone who you don't like if you'd like to waste their time on looking at this. Okay, if you have a question, besides the ability to email me there at gassman@gassmanpa.com or Kelsey, K-E-L-S-I, at gassmanpa.com, you can click on the questions arrow, and then a thing will come up, and then you'll type in your question, and then you'll click send, and then I'll see your question, but if I can't answer it, I'll pretend not to see it, and then you can email me later. Okay, we publish every once in a while a Thursday report. It often goes out on Thursday, depending upon whether we're running a week late or 2 weeks late or a day ahead or behind. If you'd like to receive our Thursday report, just email info@gassmanpa.com, Thursday report in the RE line, and we will send this to you. It's absolutely free of charge and worth every penny. We have a YouTube library that we're always adding on to. This particular webinar that we're giving right now will be put onto the top bar of the YouTube library, which is all about estate and estate tax planning. And also, I think the third bar is about creditor protection planning. The second bar is about charitable planning. And my favorite bar, I can't go to anymore. It's called the Monkey Bar. There's loud music and a lot of really interesting people. which is why I'm not allowed to go there anymore. Okay, now the FICPA Federal Tax Conference. If you're a CPA or a lawyer and you want continuing education credit, come pretend that we're in Washington, D.C., and we'll be talking about federal estate tax, the greatest show on earth. And then we'll be talking also to the Suncoast Estate Planning Council. Those of you, my friends in St. Petersburg, all three of you, you're welcome to come see us there. We are the publishers, creators, and people to blame for EstateView software. At the end of the presentation today, I might give you a little review of the estate tax law using EstateView software. Depending upon if you put that in the question mark box, would you please show us EstateView software? Then I will. We also always offer these free estate tax exemption spreadsheets. This week is no exception. I'm always looking for ideas for our book, Gassman and Markham on Florida and Federal Asset Protection Law. You can find it on Amazon or used copies on eBay. I thank Michael Markham for hardly ever working on the book, which makes it easier for me to keep it tidy. Also, we do publish what CPAs and other advisors need to know about bankruptcy. If you know Ken DeGraw, would you please send him an email and tell him that it's time to revise the book with me? And I thank Alexander Bovey for providing us with a really nice review and a really good example of somebody who cares about creditor protection, who is a gentle person and a scholar, very, very bright, and the #1 expert on trust protectors in the world. Okay, we showed these screens last week, or the last time we gave this. If you think you can't be sued, guess what? You can be. And if you think your $10 million umbrella is enough, I can tell you that I've represented people who wished they had 20 times that much coverage when it came time to defend an action. So just be careful and understand that juries can be very, very generous with your assets. But I am not going to understate the importance of being careful in the way you drive, in who you let drive your car, who you let work for you. I'll give you an example. A client had someone working for him on a farm ranch situation, and it was the time of year when people would burn all their leaves and extra wood, but in order to have a burn, you needed a permit. So what this helper did was, instead of getting a permit, he waited till the neighbor across the street got a permit. So the neighbor across the street got the permit, started the burn. My client's helper started a burn. They burned a bunch of stuff. Well, what happened? A truck rear-ended a car and caused somebody to be a paraplegic. It was at least a $25 million in damages situation. How much coverage did my client have? Well, maybe zero, because he was breaking the law by having a burn without a permit. He didn't even know he was having a burn without a permit. So please be very careful and keep your assets protected. The more assets you have, the bigger the target you are. And since it's Thanksgiving, we can express gratitude. If there was a guy named Noah and he built an ark with 2 of everything, saving everyone, he did it before it stopped raining. Thank you, Dennis Kleinfeld, for that idea. In the last webinar, I went through the definitions. It's not a bad idea to go through them again. There are many choices for creditor protection that we're going to cover here. I strongly recommend, if you're a professional, to please review all the choices with your clients, and not only the choices that make us the most money, or that tend to be the old saying, if you have nails, then everything looks like a hammer. Is that it? Or if you have a hammer, everything looks like a nail. But anyway, please beware that advisor who just pitches one product. He or she will probably be nowhere to be found if the product doesn't work. So on page 29, I'm already on page 29 in 7 minutes. For many of you, I'm sure it seems like longer. Wherever you live in the United States, you have exempt assets. These are assets that a creditor cannot reach. Under the Federal Bankruptcy Code, if you have to file bankruptcy, you can retain your IRAs up to about $1.4 million or more, your pension accounts, your 401ks, the assets that you don't own that other people legitimately own. They're not holding them for you, they legitimately own them. For example, if you're a neurosurgeon in Texas, you could put a bunch of assets in your spouse's name, and then if you get sued for malpractice, they can take them because of the community property law, unless you transmute it out of community property, in which case they can't take them. So if you truly love your spouse and you're a neurosurgeon, please put all your assets in the spouse's name, unless the spouse is also a neurosurgeon. Depending upon what state you live in, and hopefully it's not only the state of confusion, you live in one of the 50 states of the United States, then you may have access to a number of exemptions. In most states, permanent life insurance is protected, but expensive. Annuities are protected in many states. 529 college savings plans are protected in many states. The organization called the American College of Estate Council, ACTEC, ACTEC, has a pretty good website which has a comprehensive chart of what assets are exempt in each state. And we'll be talking more about this, but please remember, know your state law and get outside of your state of confusion. Further examples, and I know for you advisors, about half of the people on this webinar are advisors. I hope I'm not putting you to sleep, but at least maybe you could think about, is this the best way to explain these rules? And of course it isn't, but it's the best way that I have. So here is a single individual, also known as not married, and the car is going to be in her name, not in the name of someone else if she's driving it, because we don't want exposure for that. The IRA and 401k are creditor protected. The annuity contracts that could be purchased from a low-cost company that may charge only 0.25% a year, plus mutual fund charges, can be available. This would be a good CD alternative, because if you get sued and you own an exempt asset and you owned it before the problem that caused the lawsuit, you can generally file a Chapter 7 bankruptcy, get rid of the judgment, and keep your exempt assets. So that would include the annuity, certain types of life insurance policies with cash values, and depending upon where you live, including Florida, an account where you put your wages. That's in California also. And then if within 6 months of the money going into the wage account in Florida, you could move it into one of these other investments. In Florida, Michigan, Texas, and 2 other states, I can't remember what they are, have unlimited exemption for homestead. So I could have a $100 million homestead in Florida if I'm outside of the city limits, up to 160 acres, and I can even buy it at the very last minute, because our Florida fraudulent transfer statute doesn't apply to a homestead unless we put bad money, like dirty money or ill-gotten gains, into the homestead, or we are moving against the IRS, the FTC, the SEC, or the Department of Justice. Those are exceptions to homestead protection in Florida. Last part one, we went over homestead in more depth. So I'm not going to say a lot about homestead today. It's a very nice city near Miami as well. Now here is the revocable living trust of the single person. It does nothing for asset protection planning but cause confusion, because laymen, that's people who are not professionals in this area, understand or learn that I could put my assets in a revocable living trust, and on death, they will not have to go through probate. No one will have to hire a lawyer to transfer those assets from the name of the trust to the name of my beneficiaries, although they should check with a lawyer anyway. That avoids probate. That's the court process of administering estates. It does not avoid creditors. Now, if the life insurance is payable by beneficiary designation to that revocable trust, and the revocable trust has all of the right words, then that revocable trust could benefit children or a spouse or friends, neighbors, without being subject to any of their creditor claims or to the creditors of this individual. Now, this individual was not a good speller, as you can see there. Maybe they were from one of the states where they don't spell very good. But anyway, have a good revocable living trust, have a will that pours your assets into it, have pay on death accounts and beneficiary designations that go to the trust on your death, have language that definitely doesn't say, pay my creditors even if you don't have to in your living trust. That should be carefully drafted. Don't just buy it on LegalZoom or Rocket Lawyer or my son-in-law went to law school, so he must know estate planning. Go ahead and get that done, or at least reviewed by a qualified lawyer who understands your state law. Okay, now, what do you do to protect other assets? Stay tuned. We're going to go over that in just a minute. Now, I'm remembering 11:15 a.m. Eastern Standard Time. I had a conversation with a client on Wednesday, a very, very bright guy, bright enough to know that I was not a good explainer. He is a medical professional. His name is not John, and his wife's name is not Mary, but I didn't want to use his name. He is going to establish a revocable living trust. I hope that he buys some life insurance on his life so that if he dies, it can go to a trust to provide for Mary and their 2 children. And I'm sure Mary hopes that he does that too. She'll miss him less if he dies, but it's still the right thing to do. And then I don't want him to put any assets into this trust. Call me first so I can tell you not to do that, because they will be exposed to creditors if you do. Now, on his death, his trust becomes irrevocable. It receives the life insurance proceeds, and it's held for Mary, who lives happily ever after. She'll probably be in a better mood. Okay, now Mary is not a high-risk physician. She is a professional, but not a high-risk professional. So we may put some of their assets under Mary's living trust. She's going to have $5 or $10 million of umbrella liability insurance. No one's going to drive her car but her. She does not text and drive. She does not drink and drive. She has life insurance that will be payable to this trust or will go in a life insurance trust. Why? Whether she needs it or not, this life insurance, $2 or $3 million, will be in an irrevocable trust on her death, not accessible to John's next spouse. And that can be very important. Also not accessible to John's creditors. Now, between John and Mary, they have a joint homestead, which is in Florida. It's going to be protected from creditors. But they also are going to use something really, really nice. It's not an old new. It dates back to at least the 1700s in Great Britain, back when it was known as England. And when a married couple, we used to say husband and wife, now we say a married couple, owns joint assets properly titled as tenants by the entireties, then if John gets sued, the creditors cannot touch the Tbe assets, and John could file bankruptcy. And if the creditors are business creditors or accident tort creditors, John can bankrupt them right out. If they're consumer creditors, if he has more than 50% consumer debt, then he's going to have to pay over time, at least 5 years, to the extent he can afford it from his income stream. Now, what are the Tbe assets? Typically a bank account, a brokerage account, an LLC, if it is properly crafted. It would be an LLC also in a state that recognizes pure protection of tenancy by the entireties. That includes Florida, Wyoming, and Delaware. I prefer Wyoming for this client because we don't want his name in the public records of Florida. If you want to know about somebody in Florida, just Google SUNBIZ in their name, and Google will take you to the Florida Secretary of State website and will show you all the companies and LLCs that they're involved with. Not so much in Wyoming. Yet Wyoming has the same advantages of Florida: tenancy by the entireties protection and creditor protection. Now, John and his brother have some companies together, and they are not protected from creditors, but John can put his half of the S corporations they have into tenancy by the entireties with Mary. There can be a buy-sell agreement that say if John and Mary ever get divorced, then John's brother can buy out their 50% interest, and then he can sell it back to John. As long as Mary gets treated fairly there. You have to be careful, though, because of the TBE rules. And then the family LLC can own what I call brokerage accounts and also risk-free investments. John and Mary are about to invest in a restaurant chain in Texas, and they're going to invest in the restaurant LLC. There's no capital call obligations in the LLC. There's no guarantee obligations in the LLC. So I'm almost comfortable with them buying it in the LLC. But he's also looking at a hotel deal in Michigan, where in the hotel deal, he's going to sign, the member has to sign guarantees and agree to make capital contributions when requested. So we're going to set up LLC number 2. That's a creative name, isn't it? And it's going to own his 5% of that Michigan deal. So if things don't go well, the bankers and the other members can sue LLC 2. They will not be able to have a clean shot at Smith Family LLC. Now, if we want to be even a little bit safer, we can form a separate trust called a gift trust. It would be a trust that John and Mary set up for their adorable children, and it could own 2% of Smith Family LLC. And there could be a line like this. See the technology there? Isn't it amazing? So anyway, that line would be 3% to Smith Family LLC, to the Smith Gifting Trust, 97% TBE. Why? When Mary dies and John gets sued, his creditors will not be able to take over the LLC, even though he owns it. They will only be able to get what's called a charging order, which allows them to be paid only if and when there is a distribution from the LLC. And if we give half of the voting rights in the LLC to that gift trust and John and Mary die, the children will be less sad because the LLC will be valued at a discount and the estate tax will be less. And if John and Mary are estate taxable, John's life insurance trust can be for the benefit of Mary and the descendants. Mary's life insurance trust should be for the benefit of only the descendants because of the reciprocal trust doctrine and my lack of confidence in being able to do what we call reciprocal spousal benefit trusts or reciprocal slats. Okay, there was something for everyone there, but the state of Ohio even has a greater gift. As I said in the last talk, the Supreme Court of Iowa, rather, not Ohio, the Supreme Court of Iowa, being one of the top 51 Supreme Courts in our country, has said that when you form an LLC in a particular state, then the creditor protection laws of that state apply, not the creditor protection laws of where you live. So if John and Mary live in Colorado, which is a beautiful state, but does not recognize tenancy by the entireties and does not recognize charging order protection. Maybe it's all the gummies, I don't know. But in any event, what if John and Mary form a Florida LLC or a Wyoming LLC and they title it as TBE? and they put part ownership in the gift trust, and now they get sued, and they point to this Iowa Supreme Court case. And you know what? 7 or 8 times out of 10, the creditors may say, okay, fine, just give us 10 cents on the dollar. We don't want to have to question the Iowa Supreme Court. Hurt by a flying ear of corn. So I hope that Iowa Supreme Court case sticks. It is based upon a U.S. Supreme Court case where Justice Ginsburg said, you may have a judgment in state A, but you have to follow the laws of state B when you go around with the methodology of whether and when you can depose the debtor. So thank you, Ruth Bader Ginsburg, for having a cool middle name and also causing the predicate of that Iowa talk. Okay, I hope it goes without saying that you should use a knowledgeable advisor, not someone that you see on some YouTube video. Go to a real lawyer, one who doesn't have to have a show every Saturday at 11 o'clock just to piece together enough people so that he has a little bit of work to do. All right, Firewall protection and your S corporation. A lot of accountants believe that a corporation or an LLC that is disregarded for income tax purposes is not protected from creditors. And in fact, my co-author, Michael Markham, often says to me, well, if you are ignoring this company for tax purposes, does that mean you're ignoring it for financial purposes? And does that mean that creditors can ignore it? And I say, no. And he says, you're right, but the creditors may think they can ignore it. So he prefers an LLC that's taxed as a partnership or an S corporation. I prefer an LLC that's disregarded so the client doesn't have the expense of the tax return, whatever it is. But if you own your S corporation and it's in your name, see if there's a way that you can put it into tenancy by the entireties, if you live in a tenancy by the entirety state, or in the name of your spouse, to protect it in case you're in a car accident, or if you're a doctor and you have 2 practices. You have an accident in one practice, you lose your ownership of the other practice. These are not good things. So, and when you do your year-end planning, you can use this chart, let your CPA or tax lawyer take you through it. It's very, very interesting and helpful. Okay, one of my favorite equity stripping slides, which Marcia and I often look at in the hot tub, is the over easy new parent. Now, it used to be clients would come to me with Smith Store Inc. and they would want charging order protection. So we would convert Smith Store Inc. into an LLC and file a Form 8832 with the IRS to elect to be treated as an association. And then a lot of people would be confused because it has a new name. So what we do instead now is we use Internal Revenue Code section 368 A1F. F as in Frank. F as in your high school chemistry grade. That allows you to set up a new LLC, which owns 100% of your old LLC. It also allows your old LLC to keep its tax ID number and to continue to operate. You don't have to necessarily tell the world there's a new parent company. But now the new parent company is an LLC, and if it's owned 66% by Smith Revocable Trust and you get a judgment against Mr. Smith, you're only going to get a charging order, which is an order from the court that says if and when you make a distribution, pay the creditor its share of the distribution, but the court cannot order that a distribution be made. And in most states, the charging order is specifically known as the sole remedy of the judgment creditor. But the second thing we do here, and this is the equity stripping part of it, this is the naked truth, this is the most exciting part of the talk, we can have Smith Store Inc. owe a promissory note to Smith Holdings LLC of a reasonable amount. If Smith Store Inc. is worth $600,000 in inventory and accounts receivable, we could maybe have this be a $500,000 note. It can be secured by the assets of the Smith Store Inc. Now, Smith Store Inc. has a horrendous judgment against it. You saw that IKEA judgment. A child was killed by a dresser drawer because the parent opened the drawer and the dresser drawer fell on the child, and IKEA should have built that dresser safer. So what are you going to do here? If that were to happen, if you had a horrific event, you go to the plaintiff lawyer and you go, look, I've got $1 million of insurance and I've got 100,000 of equity. What do you mean? Well, my company signed a promissory note and a security agreement well before we ordered that dresser that fell on your client's child. We're terribly sorry about it. But if you force us to go into bankruptcy with the store is going to sell its assets to a new entity owned by my wife or cousin or even by me, and is going to pay a fair amount as decided by the bankruptcy judge. The bankruptcy judge is then going to allow us to pay Smith Holdings LLC the first $500,000 that comes out, and you're going to be less well off as a plaintiff lawyer because you'll have spent 6 to 8 weeks of your life in discovery and in trial. And you'll get a smaller percentage than if you settle before trial. Actually, you get a larger percentage at trial. Anyway, most plaintiff lawyers will say, okay, thank you very much. How much is your limits of coverage? We're done. But if you have no debt against Smith Store Inc., it is not so easy. So those are the advantages of the over easy LLC arrangement, best ordered with breakfast, hash browns, or if you're in Florida, grits. Disadvantages of the over easy LLC arrangement: you have to pay the lawyer. It does not need a separate tax return. They both end up on the same tax return. This also works for C corporations, and it works for entities treated as partnerships and as disregarded. So that's the over easy item. If you are in terribly dire straits, be glad if you have 3 creditors instead of 1. Have your friends buy the debt of the first creditor who's willing to sell their judgment rights cheap. Give that creditor a lien on all your assets, and then explain to the other creditors that your assets have no equity, and if you have to, go bankrupt. So that's, if you have multiple judgments, this is actually a very useful technique. I really only mention it because so many times debtors have come to us after seeing good advisors who did not realize that this is a very viable creditor protection situation. So the only thing better than having one big terrible creditor is having 2 or 3 big terrible creditors so that they can compete against each other. Okay, so we talked about charging orders. Please don't form your own LLC or have your CPA form your LLC. It's actually against the law for your CPA to practice law to provide an operating agreement for your LLC. Do you really want to use a CPA who's breaking the law to provide your LLC operating agreement? One thing we do in our practice is we review a lot of operating agreements, and to be quite honest, we find a lot of mistakes, even by good lawyers. So be careful. You need to have a proper operating agreement for your LLC. This isn't only for surgeons who operate. This applies to dentists who operate, veterinarians who operate, and even plumbers, because they operate vehicles. Actually, the word operate is completely not important. You can't just form the LLC on the Secretary of State website and expect that you've done everything necessary. The biggest mistakes we find in LLCs are, number 1, the language does not allow the tenancy by the entireties protection that I've discussed. Number 2, the entity documents can disqualify the S election if you violate the second class of stock rule. which you would have learned in your second class in law school if you had studied S corporations. Number 3, failure to use an intermediary entity besides just the LLC. In other words, you set up a family LLC and you put all your money and all your rental properties in it, and then a tenant breaks their neck and sues you for more than your insurance, and you lose all those other assets that you put into that family LLC. So there's other items as well. Now, what about foreign companies and LLCs? They can be very effective for creditor protection purposes. You can form an LLC fairly inexpensively in a number of jurisdictions that have the same protection that charging order states have, but they have further protection. One further protection is that the creditor may have to go to the foreign jurisdiction in order to try to attach the company interest. The other advantage may be that that country where the LLC is formed, such as the Cook Islands or Nevis, may not even recognize US judgments. You may have to file a whole new lawsuit there to try to attack an LLC. So foreign LLCs can have their uses. There's also a loophole in the international US tax law, which allows many taxpayers to legitimately set up companies outside of the United States in countries that do not have an income tax. So you set up the company in a country that does not have an income tax against companies. The company earns money there. It doesn't pay tax. You pay tax when you bring the assets back to the United States, but you have deferral and possibly reduced rates. Now, that doesn't work for everybody. It doesn't work for earned income, but it may be a legitimate reason to consider having an out-of-state LLC. So we have some articles about them. Most of our clients use Wyoming or Florida LLCs because they're every bit as good as foreign LLCs for most clients, but they are out there, and it's a nice trip to Nevis. The Four Seasons there is beautiful. St. Kitts is right near Nevis. This is where Alexander Hamilton was born, and he even has a Broadway show. Maybe you will too. You could buy a citizenship there. You could buy a home and then pay some money, and you can get a British passport, British Commonwealth passport. So in your fantasies of leaving the United States because you don't agree with the political party in charge, you could leave the United States, go to Nevis and St. Kitts, form an LLC, invite me to meet you at the Four Seasons, and get a British passport. Most clients don't, but it happens. One little interesting thing, last time I checked and every time I've checked, if you have a Delaware bank account, in order to get into a bank account, a creditor normally has to serve a writ of garnishment on the institution, but Delaware doesn't have writs of garnishment against accounts. So I once had a client who had 100 bank accounts, all less than $1,000 each, many of them in Delaware. Why? Because he figured it costs a creditor almost $1,000 to seize a bank account. So he could easily get that $990 from each of those accounts, but his creditors would have had to spend $50,000 to $60,000 to get that $100,000. So I should make a slide for that. I thought it was pretty slide, whatever you want to call it. I find that 529 college savings plans are very underutilized. Why? I'm not sure. People just don't think about them. An affluent person with a child or grandchild should normally put about $150,000 into the 529 plan, maybe $100,000 depending on the age of the child. Because remember, the money in the plan is creditor proof. It's never the growth is never subject to income tax as long as it's all spent on education. and education now includes up to $10,000 a year, kindergarten through 12th grade of tuition, plus college and graduate school and postgraduate school tuition and living expenses and computers and other necessities. So that's separate and apart from buying a prepaid tuition, prepaid dorm. I am not a fan of any Uniform Transfers to Minors Act. I think asking minors to wear uniforms can hurt their self-image. In addition, if they wear a uniform and you set up a Transfer to Minors Act, they get all the money, everything that's in it, when they're 21 or possibly in some states 25. But boy, we see a lot of immature 21-year-olds, and if the child is in a terrible accident or gets sued for child support or alimony before they even turn 21 or 25, the creditor can reach it. So we strongly prefer irrevocable trusts. Yes, it costs a little bit to draft them. They don't need tax returns, and they help you get charging order protection. If you have more than you need for 529 plans, or even the gifting trust can own the 529 plan, that can be a good thing. Okay, what we used to call a lifetime bypass trust or a dynasty trust, named after Linda Evans in the wonderful show Dallas, or actually that was the show Dynasty. I think it was about an oil family. But anyway, Spouse One, affectionately known as Spouse One, donates gifts $2 million to the irrevocable trust known as the Spousal Limited Access Trust. That's what they're called now. Spouse Two, affectionately known as Spouse Two, is the trustee, can get whatever's needed for health, education, maintenance, and support anytime he or she wants, can make distributions to the children. This trust, to my knowledge, in all 50 states, including Guam and Puerto Rico, is creditor proof because Spouse One funded it with his or her own assets and is not a beneficiary. Spouse Two did not fund it and is limited to receive what is reasonably needed for health, education, maintenance, and support. Creditors can't reach this trust. Now, you could even provide that Spouse Two could name a person or trust company as the independent trustee, and then the independent trustee could have the power to distribute more than what is needed for health, education, maintenance, and support for Spouse Two. And Spouse Two can receive all the assets back when wanted. But what's really nice about the Dynasty Trust? Number one, it's not subject to creditor claims of either spouse. Number two, it is not subject to federal estate tax. Whatever it grows into will not be subject to federal estate tax. Number three, if you locate it in an asset protection trust jurisdiction, such as Delaware, Nevada, South Dakota, or Alaska, you can put in a provision that says that if Spouse One ever has a horrendous economic problem, not expected now, then Spouse One could be added as a beneficiary of the Dynasty Trust by individuals called trust protectors, trusted friends or advisors who have full discretion as to whether to add Trust One as a beneficiary. Now, Dynasty Trust will normally be formed in one of those creditor protection jurisdictions in the United States. By the way, Tennessee now has these trusts, and if you're from Tennessee, it is certainly a viable asset protection trust state. West Virginia has them, and there's a video about West Virginia creditor protection trusts on my YouTube video, just as an aside. Not worth watching, but still cute. Is it better to put the Dynasty Trust in Nevis or the Cook Islands or Gibraltar or the Isle of Man? And the answer is, it depends. It is somewhat a concern that if for example, Florida court says, hey, you live in Florida, the creditor's in Florida, the brokerage account owned under the trust is in Florida. Yeah, you've got a Nevada trustee or co-trustee, but we think that Florida law should apply to this trust, and it's a bunch of bunkus. So bring the assets back. Then there's a question. Does the full faith and credit clause of the U.S. Constitution require the assets to come back? And the answer is unknown. Even though Alaska has had a creditor protection trust statute and trust there since 1991 or 1992, there is no decision on whether the full faith and credit clause of the U.S. Constitution will apply. So it's a good idea to provide in the dynasty trust that if all the trustees resign, the next trustee will be an offshore trustee. The trust will go offshore, and Nevis and Belize, quite candidly, don't care what a Florida court thinks or does. So that would be a second step. Now, if you start the trust in an offshore jurisdiction, you will pay significantly higher trustee fees, and you will pay much higher CPA fees because you have to file Treasury Department forms and IRS forms, including a Form 3520, and every year a Form 3520A. And if you forget to include an asset that's offshore, then you can pay very, very large penalties, which is usually not very fun. So that is the discussion of the Dynasty Trust, and we'll be showing you in 15 minutes, that's about 4/10 of a billable hour, what the utility of a Dynasty Trust might be. Now, as to life insurance and, excuse me. Oh, thank you. As to life insurance and annuity contracts, please be careful because the expenses associated with these vehicles can be significant. So understand that there can be tax advantages. For example, I could invest in a cash-rich life insurance policy that meets the minimum corridor test. So I'm 62. I could buy a $130,000 life insurance policy and over 5 to 7 years fund it with a $100,000 cash value. It only has to have $30,000 of extra death benefit. And then whatever the inside grows to is never subject to income tax as long as I die with the policy intact. Now, if you're under age 40, I'm jealous, but you would have to have, if you had a $100,000 cash value, you'd have to have another $150,000 of mortality benefits in the policy. And the more mortality benefits you have, the greater. So the nice thing is I could borrow from the life policy and still not pay any income tax. I could take money out of the life policy and withdraw up to how much I've put in, my basis, without paying tax. And then what's left when I die is never subject to tax. But you have to weigh those benefits against the cost of the product. And we spreadsheet those for some clients who ask us to. It can be very interesting to compare policies and to compare strategies that you have with policies. You can exchange your life policy for another life policy that may be more efficient, but the transaction cost can be high. So you really have to ask for very careful and full disclosure of what's going on and who's getting compensated and how much is being taken out of that policy each year by the carrier if you go into a life insurance or an annuity contract. Now, I could go ahead and buy $1 million cash value policy with a $2 million death benefit and borrow $1 million from a bank. Well, that's a bank calling me now. See, it's Marcia calling me. Hey, Marcia, I'm giving the webinar. Say hi too. Okay, I'll call you afterwards. Bye. You love the Apple Watch. Way. I borrow $1 million from the bank. I buy a life insurance policy, and I give the bank as collateral all the assets of my law practice, all the assets of my bakery, all the assets of my art collection. And I owe the bank $1 million. Bank agrees that if I file bankruptcy or I default, that they will chase the other assets first, and that they will only take my life insurance policy last. Now, will that protect my assets from creditors? Maybe, maybe not. There's something called the Marshaling of Assets concept that most people don't know about, that a bankruptcy judge could reapply how that works and allow a judgment creditor to get a bigger piece, but it's a pain. So that might be a good strategy. But be careful if you borrow money to buy anything. Remember what happened in 2006, and there are life insurance carriers that have not performed as promised, probably over 1,000 of them. So we had a client whose carrier went bankrupt, and it was a horrific situation. If you don't believe that a life insurance policy can be in bankruptcy, just Google the Shenandoah Life Insurance Company. Shenandoah, where are you? I love your valleys. And I loved losing significant cash value in your life insurance policy and watching you in receivership for 3 years while negotiating with other creditors. That's what happened to a client of mine. Okay, IRAs and pensions, have one. Put as much as you can in them. Enjoy them. The IRA can be payable to a trust on death that protects the IRA benefits from creditors. If I have my IRA payable to a child of mine, number one, the child one could lose it in a divorce. Child two could lose the IRA to creditors, depending on whether the state where she resides protects her from creditors or protects her IRA from creditors. Child three may gamble it away or spend it on illegal drugs or legal but not very good drugs, or what do I mean? Drugs that have bad impact. Or number four, it could be given to a cult. We see all this stuff happen every year. So why not leave child one in a trust? The same distribution rules can apply. What the distribution rules are now is you have to take it out by the calendar year that is 10 years after the calendar year of death. So you don't have exactly 10 years. If you die on December 20th of 1 year, then you can take it out. Then you actually have 10 years and 300 and some odd days, 357 days. I'd have to ask Alexa exactly. But you have at least 10 years, as long as there is stretch language in your trust. Now, how do you put stretch language in your trust? We have special paper that stretches, you know, just like they used to stretch money in the cartoons. Actually, the stretch language says that from the September 15th, after the calendar year of the date of the IRA owner, from that day forward, the IRA cannot be used to pay to creditors or to any one of a number of exception entities, such as even a charity or a company, only to people who are countable people. We have a whole book on it. But the moral of the story is, don't leave assets directly to people. They're not worth it. You see, we even cut out child number 4. Child number 4 apparently was hopeless, or my word processor forgot to put in child number 4. If you are the 4th child in your family, you have my apologies. Okay, we talked about homestead last time around, so I'll leave it to you, to your own devices, to deal with homestead on your own. Okay, if you are in a community property state, Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, Wisconsin, say it with one breath, then in most of these states, if someone has a judgment against one spouse, they can take all the community property and all the assets accumulated during the marriage are community property. So see a lawyer about what's called transmuting out of community property. Do you transmute? Well, you go on Star Trek to the holodeck, and Mr. Scott will transport you and your assets to a different state. Actually, you could still live in California or Texas, where a lot of Americans live. I think those are the 2 most populated states in the United States. The 3rd one is Florida. The 4th one is New York. I always like to say that in front of New Yorkers. So the married couple transmutes out of community property, puts the assets in the revocable trust or an LLC primarily owned by the non-risky spouse, the less risky spouse, and build the estate plan around that. Now, an advantage of community property is that on the death of one spouse, you get a full step up of income tax basis. So if you paid $100 for your Bitcoin and now it's worth $1 million, and you're in a community property state and one spouse dies, now the surviving spouse can sell the Bitcoin for the $1 million and pay no capital gains tax. By the way, I don't have Bitcoin and I don't encourage the purchase of Bitcoin, and I sure wish I had bought some before. So the couple who transmutes out of community property treatment is going to lose out on the stepped up basis on the first death unless they invest in something called a joint exempt step up trust, a JEST, or a similar power of appointment estate planning arrangement, which is complicated to draft and implement, but certainly worth looking into, in my opinion. If you want information on the JEST trust, you can just ask me about it, and I'll be glad to send it over. Domestic asset protection trusts, we have discussed them. There's literature on them. A lot of the estate tax planning trusts that we form are asset protection trusts because if I form a trust and my creditors can reach into it, then on my death, the IRS considers it to be my asset because I funded it, and I can go run up a bunch of debt and get it paid from the trust. So really, I can benefit from the trust. So that's the reason that a lot of our estate tax planning trusts are set up in asset protection jurisdictions. On the other hand, for example, if you sold assets to your asset protection trust and got back a note, and now you want to protect that note from creditors, you might put that note into an LLC. Keep the 1% voting member interest in the LLC and transfer the 99% voting member interest in the LLC to another asset protection trust. So a creditor can't get hold of that note. In fact, if that LLC is owned 2% by a gifting trust for your lovely children, 98% by your Nevada trust, and that owns the note, someone gets a judgment against you, yes, maybe they could break into the Nevada trust, but are they going to bother? Even if they do, they're only going to get a charging order against the LLC, which will not allow them to reach the note. Hopefully they will settle for dimes and nickels on the dollar. Please consider the marital asset preservation system. If one spouse may die, well, any spouse may die, why not have a written agreement? Marcia, assuming you don't call me again during my webinar, I promise that if you die first, I will form an asset protection trust in Nevada only for me and our children, not for the next spouse. No matter how nice that next spouse may be, I have a binding legal obligation to form the marital asset trust. And therefore, my formation and funding of the trust is not considered to be a transfer for the purpose of avoiding creditors. It's a transfer to fulfill my financial obligation. So there's information on the foreign asset protection trust. Now, if we do part 3, I will go through this Lineberg article that Mike Markham and I wrote when we thought the world was going to end in March of 2020. Remember that? I thank my financial planner for reminding me for the 150th time, don't try to time the market. Just when you think there's going to be a recession, the prices go up. Just stay in the market. Keep your allocation the same as it's been for the last 21 years. Stop calling me. Just pay my invoices. That's a good financial planner. But anyway, I've got 22 definitions, 33 strategies, and 26 traps for the unwary in this article, which you're welcome to read. And then we also, just so you know, we have some slides from an ABA presentation that I gave in January of 2019. Most of the slides that you'll see here are fairly up to date. You like that legal term, fairly up to date? Here's a slide I like, page 175. You got the widget business and the factory, and the widget business is unprotected, $1.8 million in assets. It's an S corporation. You tell your accountant, I want the widget business to owe money to my family LLC. The accountant says, well, you can only owe $800,000 because anything above that is going to cause a tax. So what do? You form the new over, the easy over holding LLC. Now you can owe as much as you want to the holding LLC. I was criticized for showing this technique by a well-respected bankruptcy lawyer who said, now, Alan, you know that this might not work. To which I said, yes, but in my experience, these types of arrangements and negotiations have worked very well, and they've even worked sometimes in bankruptcy, right? To which he said, right. So one of my sayings in the asset protection world is that perfectionists do not always win. You've got to do something to make it, to put your assets in that briar patch. And then one more thing, sorry for my exuberance. If you have a leasing arrangement, consider setting up a master leasing arrangement. So this was a horse stable operation, high risk. So this is the horse stable company. It has a triple net lease of the property from another company. Then triple net lease follows all the Florida case law on how to keep a landlord out of the mix when somebody breaks their neck on the property, because the tenant has full control of the property. We have everyone who deals with that stable sign waivers as well. And then, just in case, the landlord company owes a note to the holding LLC. And the holding LLC is owned by the Nevada Trust Company. So, once you illustrate these things, you can come up with fairly nice results. Okay, now to answer some questions. Hello, what was that site you just mentioned that listed asset protection by state? ACTEC, ACTEC. And if you go on their website and search asset protection, you will find a really nice chart that's kept up very nicely. Okay, Alan, got my intro from Gideon Rothschild many, many moons ago, hoping you again have some updates I'm not up on. Thank you very much, Norman. And hats off to Gideon Rothschild. He's a very good creditor protection lawyer in New York, very well respected. How about HSAs for asset protection? It depends on the state you're in, but HSA, which is a health savings account in most states, is creditor protection. How about a Roth IRA for a grandchild? That's a great idea. I wish my grandfather had given me a Roth IRA instead of a fishing pole. Okay, are assets in the joint revocable trust stepped up on the first dying spouse or not? Yes, if you form a joint exempt step-up trust, which could be owned 95% by the low-risk spouse, 5% by the high-risk spouse, you can get a full step-up in basis on the first death, in my opinion, and according to some peer-reviewed literature and someone I met in a bar. Okay, those are the questions. Now I'm going to show off the Estate View software. I needed to video this for the law students because the law students had their finals just before Thanksgiving. So thank heaven they're back. And one of the things they're going to do is write about this software and give me a new brochure for it. So I wanted to explain how it worked. And here's how it works. I open the software program. I put my firm name there, my planner name there, the name of one spouse, call him Bob Sample. He's 62 years old, so he must be a really bright guy. Now I see his normal life expectancy is 2039, but if he uses tobacco, it's 2036. Probably not worth it to use tobacco then. And I'm going to give him until 2042. His lovely spouse, Mary, is, make her 58, and we'll give her until 2054. And then they have a $1 million home going up at 3% a year. They have $15 million of investments going up at 7.23% a year. Their investment costs are, I'm going to say, 0.4% a year. And their annual tax on investments is 0.8% a year. They save $350 a year because he's still working. And after his death, they'll save $50,000 a year from royalties from his business. So they believe that the estate tax exemption will be going down to half in 2026. And they believe that portability, which I'll mention in a little while, is available. So if one of them dies without using her whole exemption, the surviving spouse can use the exemption. On the first death, they want to put away as much as possible to benefit the surviving spouse without being subject to estate tax. And the most that can be based upon this scenario is right there, 10,790,000. You see, I arrowed up as high as it would let me, and it's got a safety there. Then they do want to annually gift to their children. There's nothing in their gift trust right now, but there's 4 children, and they want to gift ownership interest in a company that they can use a 35% discount. So we'll put 30, or we'll use a 30% discount. And then $1,650,000 life insurance policy on the husband's life is paying $9,000 a year of premium, and it's a 20-year term policy. And that's what we have so far. So here is a good way to explain the federal estate tax system. Now, on the right-hand side, let me show you a little bit more about the software. If they both die today, then the results are shown on the screen right now by clicking this box there. If they do no planning, and they go and die based on the scenarios we showed you, they will pay $65 million in estate tax. Is that believable? Is that believable? Look, these people have a $16 million net worth, and the estate tax exemption is $11.7 million. Why should they worry? In fact, let's assume that the estate tax exemption is only going to go up. It's not going to come down to half in 2026 as scheduled. I'll click that box. Well, let me go back here. No planning. Now I'll click the box. What happens if the exemption goes back up, doesn't go back by half? They still have a $60 million estate tax. How does that happen? Let's look at the numbers. We have the residence worth $1 million, investments worth $15 million, life insurance of $1,650,000, growing at 7%, minus fees, minus taxes. Plus they're getting an extra $350 a year that they're adding. When he dies in 21 years, she's going to have $80 million to deal with. And when she dies 13 years later, she's going to have $148 million. So maybe you say, well, you know, most people wouldn't be saving that much. Let's spend it. Right? We could take that to zero and take the 50. In fact, say that after he dies, she's going to spend $150 a year. All right, so here's where they are now. No planning, of course, no tax because they're not over 22 million. But but that's only if they both die immediately. If they don't do any planning, they're at a $40 million tax. Well, on the first death, when he dies, how much can we put in the credit shelter trust? Based upon the adjusted numbers, 21 million. That's based upon 3% inflation and the exemption growing for that many years. So I'll click here for bypass trust. And now we're showing you that on the first death, 21 million goes into the bypass trust. And on the second death, the bypass trust is not subject to estate tax. And if we have the life insurance and a life insurance trust, now we've got the estate tax only down to 20 million. So why would we even worry? It's only $20 million. But how are they going to fund 21 million in a credit shelter trust? Well, let's assume that they're not going to, and that they're going to rely on portability. So this allows me to discuss portability. What is portability? Portability has nothing to do with mushrooms. Portability is that if he dies and he doesn't use his exemption, then she gets his exemption. So I'm going to click that portability will be available. So what should be a difference there? Maybe we have a wardrobe malfunction. Okay, if portability is available and we do not use the credit shelter trust, then the taxes are a lot higher. And that shows you, so see, with portability, she dies, nothing gets put into the, he dies, nothing gets put into the credit shelter trust. She gets his leftover 11.7 million exemption, but it doesn't grow with inflation. And it doesn't capture assets growing at 7% a year. So with portability, you have a $30 million estate tax. But on the other hand, if you take away portability and you maximize the credit shelter trust, you have a much smaller estate tax. So that's why we want your credit shelter trust to be fully funded on the first death. Now, if you're a doctor and we don't have any assets in your name and you die first, and we don't have a fancy power of appointment trust in place, then we've lost the ability to fully fund your credit shelter amount. This will be more pronounced if the first dying spouse dies earlier, and we're getting tired of them anyway. So we can go ahead and reduce his life expectancy. Like, let's say he hasn't paid our bill. So we're going to reduce his life expectancy. He's going to die. Oh, come on. We'll say 2032. All right. So now the most we can put in his credit shelter trust is 16 million. Still a $9 million federal estate tax on a relatively small estate of only 15 million. So what about annual gifting? So we click on annual gifting, and they've got 4 children, so that's 60,000 a year per child. So you see this gifting trust after the first death is going to be worth 2 million, and after the second death is going to be worth 15 million. So that's going to handle a lot of their problem. We've got the estate tax down to 3 million. But what if they gift discounted interest in LLCs, which also provide creditor protection? I can click discounted gifting, and now look at that. The estate tax went down from 2,899,000 to 283,000. But see, this assumes that their asset, and now the life insurance trust can also be shown. But this assumes that their assets will only grow at 7.23%, which is the average for a normal, reasonable portfolio. But maybe they own a business, or they're going to have better performance. Let's say that they perform based on the S&P 500 average, which I think is more like 8.75%. Well, now they still have a $17 million estate tax issue. So this is where, should they set up a dynasty trust now and put in $3 million? Will that, and $3 million into the dynasty trust, how much will that reduce their estate tax? Well, right now they're at 17. Right now they're at 16 million. How is that working? Let me go back to there. The more I put in this dynasty trust, the less their estate tax will be. If they put $1.5 million in the dynasty trust today, the estate tax is 12 million. If they put $3.2 million in the dynasty trust today, the estate tax is 6 million. So that dynasty trust right there, you put 3 million in today, it's worth 7 million in the year 11. And in year 33, it's couldn't be worth 45 million. Okay, something's wrong with the program. Not sure what it is. Sorry about that. But there still will be estate tax savings. What they can also do is they could sell assets to the trust. They could put, let's see here, back to installment sale, open it up. They could put $1 million worth of assets, or let's say $3 million worth of assets into the trust, reduce their gift there to 250,000, put $1.1 million worth of assets into an LLC, assuming a 30% discount, sell the 99% interest in the LLC to the trust for a $2 million note, bearing interest at 2%, and we will make it a 20-year note. Look at that. The longer the note is, the less the estate tax will be, because the note is only bearing interest at 2% instead of growing at 7% once the note is paid in full. You can use a note up to the life expectancy of the client. So that gets their estate tax down to 2 million. What would I have to do to get their estate tax completely eliminated? $1,250,000 gift today and $3,400,000 in the installment sale. So going back again, no planning, no tax, if they die this year, but without planning, 66 million in tax. Bypass trust brings it down to 29 million. Annual gifting brings it down to 20 million. Discounted annual gifting brings it down to 17 million. And the installment sale brings it down to no tax. Another way you can show this is if you click on timeline. This shows that on the first death, the blue is the installment sale trust. The red is the gift trust. The yellow is the bypass trust. The green is the personal residence and investments. And the estate tax is red. So, for example, here, if I show annual gifting, this is where the estate tax starts on the first death. Now, they may say, well, what if the first death is sooner or later? Well, you could just move that line and it'll recalculate based upon when that first death is. If you could get him to die earlier, there's less tax. But if he's going to live a long time, then there's going to be more tax. We're going to have to go back to the drawing board. Even with the installment sale, if he's going to live a long time, we're going to have to do a larger installment sale. So I'll click here until the red is gone. And oh my gosh, it's really hard to get rid of the tax now. They'd have to give more than their net worth. They have a tax issue. So they may want to buy more life insurance, because without the life insurance trust, it's an issue. Now, to explain all this, I click here, generate client letter. I click generate client letter, and then a Word document has opened and come into our life. I open the Word document, and there is the document, which explains the situation. Kelsey, we can send this to all the attendees today. If you're not an attendee, but you see this on YouTube, just email info@gassmanpa.com and put send Word document. This gives you all the inputs. It explains the system. It can be modified as a Word document. So now if you want to compare strategies, you just run a different scenario, run a new Word document, and then you can compare the Word documents, not as a red line, but just to explain it. So that's as far as the software has gone. Kelsey's husband is a software engineer, so he's working to improve the software. There's one more thing that the software does, that's the installment sale calculator. By the way, the software can become untacked and you can run it on dual screens. So if you wanted to, for example, move this to a separate screen, you can move it around. But I'm going to go back to this installment sale calculator here. This is a different module. This is for a single individual, and it gives you, generally, you input initial assets, the annual saving or spending rate of the client, the rate of assets, the income tax rate as a percentage of assets, the annual exclusion rate, the annual exclusion that the client has left, then their seed capital gift, sale value before discount, the discount rate, how much is in the LLC. When you snap one, the other snaps in unison, saves a lot of time in calculation. If you want to see a 30% rate, it instantly does it. Here's your note amount. Here you can put your interest rate. Here you can put your estate tax rate. Here your CPI for the exemption included. In both modules, we have self-canceling installment notes, which I can explain later. And then you can tell me the term of the note here, when you might want to cause the trust to pay its own taxes as opposed to the grantor paying the taxes, and the number of years that you want to project. And then it runs the spreadsheet for you with the assets. Sorry about that. I can hit fit with, and that gives you the assets without the note, the growth, the annual spending, So if you change any one number, all the numbers change instantly. The income tax that the trust pays, that the client pays, the taxable state for his exclusion, and then the estate tax liability and the estate tax savings from the arrangement. It certainly shows you that if you go with a self-canceling installment note and the client dies early, then the estate tax savings is going to be very considerable. And this will tell me how much I need to sell to get the estate tax down to 0. It would have to be a pretty large sale in this situation, but it can work. So that is our webinar for today. I really appreciate the opportunity to present like this. It's a lot of fun. I will call Marcia back. Call Marcia Gassman. We'll let her know that the webinar is over. If you have any questions, comments, or suggestions, we do very much welcome them. We are a law firm in Clearwater, Florida. And thank you very much. Have a fantastic rest of your weekend. Hey, Hon, we're done.